Today is October 14, 2025. A significant and urgent demand is now being directed at the French government from a coalition of human rights organizations. They are calling for an immediate suspension of a bilateral treaty with the United Kingdom, a deal informally known as the One-In, One-Out Agreement. This treaty was designed by both nations to manage the relentless and often perilous flow of migrants crossing the English Channel in small, unseaworthy boats. The core of the issue, according to these groups, is a growing fear that the agreement may be causing significant harm and violating fundamental human rights. They are not asking for a permanent end, but for a critical pause, a moment to rigorously assess the rules and their real-world consequences on vulnerable people. The treaty itself is a recent and pivotal piece of cross-channel cooperation between Paris and London. It represents a joint effort to get a handle on a situation dominating headlines and political discourse for years. The sight of dinghies packed with desperate individuals has become a symbol of a complex global challenge. Yet rights groups argue the policy's impact may be undermining those very protections it claims to uphold. So what exactly is this treaty? At its heart, the agreement is between the United Kingdom and France aimed at managing irregular migration across the English Channel. The central mechanism is the one-in, one-out principle. For every migrant returned from the UK back to France after an unsuccessful asylum claim, or for being deemed inadmissible, the UK coordinates a rapid return to France. In return, the UK accepts one refugee from France via a designated safe, legal route. A quota sets how many verified refugees can be resettled. Selection prioritizes vulnerable people and families with legitimate protection claims. The goal: deter risky crossings by making legal pathways the only viable route. Despite stated intentions of safety and order, human rights organizations have raised serious red flags. Their primary concern revolves around the fundamental right to seek asylum. Refugee Council Liberty argues speed and inadmissibility conflict with international and domestic law, including the 1951 Refugee Convention. They worry one-in, one-out treats people as interchangeable numbers rather than individuals with unique, often traumatic histories, entitled to have their case heard in full. If legal pathways are too slow, restrictive, or inaccessible, people may be pushed toward more dangerous clandestine crossings. The concerns are not theoretical. They are backed by anecdotal evidence and emerging case data. Lawyers report individuals flagged for return within hours of arrival, leaving little time to secure counsel or prepare an asylum case. One example: a young man fleeing political persecution with clear evidence on his phone told his claim was inadmissible before he could present it. Journeys are fraught with peril: overcrowded boats, faulty engines, insufficient fuel, busy shipping lanes and cold waters, and the terror of hours in darkness. In response, both governments mount a firm defense. They present the agreement as necessary and pragmatic to save lives and restore order. The stated priority: stop the evil trade of human smuggling. Officials say smugglers endanger lives and charge exorbitant fees. They argue the treaty breaks the smugglers' business model and prevents tragedy. France frames its role as responsibility and cooperation. Both governments insist compliance with international law and respect for rights. They call one-in, one-out the compassionate part. For each return, a safe resettlement. A symbol of managed, controlled immigration to sustain public trust. Those who believe the treaty is unlawful have paths to challenge it. The most direct route is through the courts. Human rights lawyers can bring individual cases on behalf of those facing return, seeking judicial review of decisions made unlawfully, irrationally, or without proper procedure. Courts can halt removal if fair hearing or family life is at risk. A broader challenge could target the policy framework itself. Arguments would engage the Refugee Convention and the Human Rights Act. Parliamentary committees in both countries can summon ministers, demand evidence, and release impact data. Independent watchdogs inspect processes and humane conditions. International bodies can issue guidance and exert moral pressure to uphold obligations. Their statements carry weight even without direct enforcement power. If France pauses the treaty, one-in, one-out returns from the UK would halt. Arrivals would likely enter the standard UK asylum process. Individuals gain time to access legal advice, gather evidence, and have claims evaluated. In France, a pause complicates matters. Legal pathways narrow, frustration may rise. UK systems face more housing, support, and processing pressure. France loses a key deterrence tool along its coastline. Crucially, a pause creates space for an independent, evidence-based review. Legalities, screening fairness, family unity, and transparent data can be examined. The aim: reform the framework to respect rights while addressing safety and security. Refine cooperation, do not abandon it. A pause carries risks and political challenges. Removing the threat of quick return could be seen as a pull factor. Smuggling networks may exploit a perceived window of opportunity. Dangerous journeys could rise, putting more lives at risk. Politically, London faces pressure after pledges to stop the boats. Bilateral cooperation could fray, complicating future security efforts. Cross-channel security built over years could unravel. Root causes, war, instability, poverty, would remain. A pause shifts mechanisms, but doesn't fix systemic asylum flaws alone. It must be managed with a clear, pre-agreed strategy and interim measures. Commitment is needed to revise, not abandon, cooperation. The call to pause France's one-in, one-out treaty marks a moment of reckoning. It pits the protection of vulnerable people against goals of border security and disrupting criminal networks. The demand is not to abolish control, but to ensure it is humane, legal, and transparent. Groups seek a temporary halt for an independent investigation into safety and fair asylum. Governments say the strategy saves lives and creates order. But reports of rushed procedures, separated families, and scant legal access persist. A pause offers space to examine evidence and hear those affected. Then implement robust safeguards. Strengthen legal pathways. Hear individual cases fully. Prevent refoulement. Beyond one treaty, this speaks to our values and the rule of law. Human rights groups argue a moment of reflection is needed to fortify justice and dignity. The challenge: will both governments listen and act before more harm is done?